Let's get right into this video. This is particularly important because I was talking with somebody during one of the live sessions that I do on Tuesday and Thursday nights. You guys know what I do. I go live and I answer questions related to Social Security benefits from anybody that calls in, which is spicy, very sassy, a little bit, drippy, but very saucy. I'm put on the spot right there. And what I realized was that an individual brought up a Supreme Court decision about how they pulled back the Chevron case, the Chevron Doctrine, and put a new one in place. And what we're going to be answering today in this video is basically how the Social Security Administration is likely to change as a result of this Supreme Court decision. Now, ultimately, a mini baby summary about what this video is going to be about is what powers will the commissioner of the Social Security Administration likely not have in the future? And then as a result of that, what things are going to change when it comes to your benefits and how courts will adjudicate them, judge them, in the future. So just to give you a basic understanding real quick as to what happened, I pulled up this one article that I liked. It was from whitecase.com. U.S. Supreme Court strikes down Chevron Doctrine, what you need to know. So let me go through this in detail. I'm going to annotate it like I normally do so you have kind of like a more, running on the ground, understanding practical application, understanding what's actually happening at the highest court level. Because remember, we have district, circuit, and then the Supreme. Supreme Court is like, that's it. Top of the morning, that's the top right there, right? The Supreme Court technically is more powerful than any of the other groups in the government, but at the same time, it is the least powerful of all the groups in the government. It's one of those weird things where they have the power to overrule pretty much anything, but at the same time, they can just make new rules that then have to go through the process again. So super powerful, or you can look at it the other way. They're just a waste of time. It's either way. On June 28th, 2024, the U.S. Supreme Court issued a landmark decision in Loper Bright Enterprises. Remember that word, Loper, versus Raimondo, overturning Chevron USA versus National Resources Defense Council and the federal judiciary's 40-year-old practice of deferring to agencies reasonable interpretation of ambiguous federal laws. So what that means is that they would allow agency heads, commissioners, big bosses of these agencies like the Social Security Administration, the commissioner, to go ahead and figure out what the application of a rule would be when it is ambiguous. So if Congress passes something and it's not like on this day at this time this is going to happen, but it's more like, and we want to go in this direction, right? With the laws in this direction. When you do that stuff, the expectation under the Chevron claim was that the head of the agency would just create some rules and regulations that would dictate essentially how that rule was supposed to be followed. Now, obviously, when you allow the head of an agency to make rules, even though they're technically not allowed to really make law, what you do is you basically create a situation where the rules and regulations made in that agency tend to be pro-agency, anti-client, or anti-beneficiary, or anti individual that's interacting with that field, which is exactly what happened. Okay. In a 6-3 decision, Chief Justice Roberts wrote that the judiciary has the sole prerogative to say what the law is. So what they're saying is, instead of these high-level executives at the agencies deciding how that ambiguous law is going to be figured out, what they're saying is, well, let's just let the judges figure it out in federal court. That's what they're saying. The demise of Chevron provides new avenues for regulated industries to challenge their regulators. At the same time, the court offered scant guidance to lower courts deciding agency rulemaking challenges in a post-Chevron world. Loper, remember that's the new rule now, Loper thus presents both opportunities and risks for regulated industries and may cause significant uncertainty in the near term. Put another way, this Loper, the new case, the new standard by the Supreme Court, is essentially not well laid out. Normally, when the Supreme Court approaches a totally new standard, they're going to give some bullet points as to what they want. Well, not always. I mean, they haven't been great at that. But again, in this instance, they didn't put a bunch of bullet points as to how lower judges should adjudicate and figure it out. So that uncertainty, that ambiguous land of how these future judges have to figure it out instead of the heads of the agencies, they just threw it on to those judges. Okay, so that's why this is a very tricky situation for the Social Security Administration, your disability benefits, your retirement benefits, your supplemental security income benefits. All right, let's go through some background on the Chevron Doctrine. Remember, we're talking 40-plus-year-old, well, technically 40-year-old situation where the case was decided in 1984. The Administrative Procedure Act, APA, establishes a private right of action to challenge federal agency actions. So you can sue federal agencies if you feel that your rights to be in that industry are being violated. This is unlike your rights to your Social Security benefits, which you technically don't have a right to. It's just a tax that you paid because the entire system was codified under the tax provisions of the Constitution, which, to be fair, is how you do it if you're not sure how to do it the right way and you just want to get it through, which is kind of what they ended up in. That's what they ended up in. Instead of giving Americans a privatized right to their Social Security benefits, instead, what they gave them was a tax with no promises, because they said, look, if we got to change the program and you got to get less, we're going to give you less and you're going to have to suck it up. And that's basically the problem we have ever since 1937 when the Supreme Court ruled on your benefits. All right, so the APA gives you a right to sue. The APA empowers courts, for example, to review and invalidate agency action found to be arbitrary or capricious or in excess of statutory jurisdiction authority or limitations. So put another way, if they make a rule, right, if they make a system, if they make a thing that you got to follow, and it is either arbitrary, capricious, or in excess of statutory jurisdiction, meaning, it was beyond the agency's ability. The agency was making law that should have been actually done by the legislator, the House and the Senate and the President giving the sign off, right? Diana Fernandez, thank you for the $10 donation. That's absolutely awesome. The adorable doggies will love those treats. We got Shadow on the green screen over there, and Sweetie is right next to the drum kit right over there, so that's excellent. So basically, here's the deal. Final regulations issued by federal agencies through the standard notice and comment rulemaking are generally subject to judicial review under the APA. But in reviewing those regulations, courts have typically given federal agencies some degree of deference. In other words, what the saying is, look, you got to post a rule that you want to make the actual rule, right? If you got a policy you want to put in place, you got to post that thing so that everybody can take a look at it and figure out if they want to be with it. And then as a result, judges, after everybody talked about it, went back and forth on it, all that jazz, judges would go, okay, well, everybody kind of looked at it. Everybody kind of was part of that discussion. Agency passed it through. Now it's the new rule. We'll follow it to some degree, unless we see that there's some egregious issue with it. That was the standard we used under Chevron. We use it with the SSA. In fact, one of the new rules that's basically about how they can access what you're paid instantly through payroll for their digital dollar sequencing, that's going through the same thing right now, the exact same thing. Most famously, in its 1984 decision, 2 years before I was born, Chevron USA versus National Resources Defense Council, the U.S. Supreme Court set forth a two-part framework for resolving challenges to an agency's interpretation of a statute it administers. Okay? The test was deferential to administrative agencies. In other words, the judges leaned back and said, agencies, figure your shit out. If everybody's on board for the most part, we'll go with that. Okay? Under Chevron's first step, the reviewing court must determine if Congress has directly spoken to the precise question at issue. So first off, when they look at this and they're looking to see, okay, did the agency overstep their bounds? What did they do? Did this agency make something that was already figured out? They look to the legislature and say, legislature, did you already figure this thing out? Did you already create the big boy law at the federal upper level, right? Did you already create law that the administration has to follow? If they don't, then we go to the next step. If Congress has done so, that is the end of the matter for the court, as well as the agency must give effect to the unambiguously expressed intent of Congress. So Congress always wins. Well, technically, the Supreme Court always wins, but on the little stuff, Congress always wins, okay? But if the statute is silent, right? If the rule that was made, the big rule, is silent on something, like it doesn't talk about that that little space in between the paragraphs where something popped up. There was a problem, and now we got to figure out what to do, right? If the statute is silent or ambiguous, ambiguous is tricky because, to be fair with you, ambiguous, that's a lot of different things to a lot of different people. But, a bright line version of that is like, on this day at this time, this must happen for this amount, versus we want the agency to accomplish these tasks. And then they cut it off at that. Ambiguous, not ambiguous. We know exactly who, what, when, where, and all that jazz. We know the parties and we know the direction, but we don't really know the details. That's the ambiguous, okay? Okay, so, but if the statute is silent, there's nothing about this problem in it, we don't know how to fix it from what Congress gave us, or ambiguous with respect to specific issue, then the reviewing court proceeds to ask whether the agency's answer is based on a permissible construction of the statute. In other words, can the agency make some little in-between law, like the law that's kind of like in between what Congress was talking about, okay? Super thank you to Diana Fernandez. You gifted a membership, which is absolutely awesome. I super appreciate those memberships, guys. All the things that you guys do are super appreciated. A little side note, just so you guys know, the SSA is not doing super financially well. It's a sad thing. I'm going to tell you something I probably shouldn't tell you. The SSA hasn't paid the law firm for 2 months any checks of a lot of claims that we won. They're just in a very bad spot. So it's one of those things where literally for the past month, the law firm was actually subsidized by the YouTube channel, which is just insanity, absolute insanity. But when people question, like, where's the SSA at on how they're doing? Bad. Like, very bad. Commissioner Martin O'Malley is doing an amazing job, but he was literally handed, unfortunately, the Titanic ship as it was like midway down on its way to where it would rest forever kind of gig. So I think he can float it, though. I think he can float it. Sen McGuire, $1.99 donation. Super appreciate it. Okay. So I'm going to do a whole thing on the 1937 Supreme Court decision. So let me answer that question that you had there when I do that video, because I actually have that as a side video where I've got like a Word doc that I go back to every week. And it's an interesting read. It really is. It's not an easy read either. It's kind of like reading the Bible. It's not an easy read. Okay, so let's go into this. In the second step, the court's inquiry is whether the agency has adopted a reasonable interpretation. Again, reasonable, super ambiguous term, like what's reasonable, not whether the court would have adopted the same interpretation in the absence of administrative interpretation. So what the saying is, the question before was, did the agency do the right thing and make up a mini law that everybody was like, yeah, that makes sense? Or, right, would the court have adopted the same interpretation? Would the judges have figured this out in the same direction and done this thing? Because remember, if the judges come up with a new direction and a new way that the test has to be done, technically they're making law, even though they'll always say it's not my job to make law. Although the higher judges, we start to get, right below justices and into justice land, they make law all the time. Okay. Chevron rests on an inference of legislative intent, saying, I guess, that the agencies have the ability to make law, which a lot of people, especially when the EPA comes up, people get very upset about agencies' ability to make law, because a lot of people feel that they don't have the, technically constitution-wise, they just don't really have that, Although, and that's the thing is, it worked with this, right? Because think about it. In law, there's what it says, and then there's like what everybody does, you know what I mean, to make it work. That's how it works. That's how it worked for a long time. That's how we did it. We have that with our hearings. We have the rules, and then we do the procedure as we know it works best. That's just how it is. That judges get very, very frustrated with a lot of people that are unrepresented when they walk into that hearing office, because they don't know. And they don't know how it's supposed to go. They know some generalized rules of where it's supposed to go in a direction, and then they don't follow the way it's supposed to be done based on the culture of it. So it's a very tricky situation. Okay. So the Supreme Court had presumed that Congress, when it left ambiguity in a statute, meant for implementation by an agency, understood that the ambiguity would be resolved first and foremost by the agency, and desired the agency, rather than the courts, to possess whatever degree of discretion the ambiguity allows. Because, it makes sense, right? You let the court figure out essentially it makes sense. If the agency has a head to it, that head, right, the boss, the commissioner, whatever, is probably going to know the system really darn well, right? Or it could just be a figurehead. But they're probably going to know what the hell they're doing. And they're definitely going to have a bunch of attorney advisors telling them you could do this, you could do this, you could do this, you could do that, right? So the likelihood that you're going to end up with a good, move, a good baby law out of the agency was pretty high. The problem, though, is that they would get off track. And then when they get a little off track, they got greedy. And then the agency kept making decisions in the direction of what's best for the agency and not what's best for those people interacting, the U.S. citizens who are interacting with that agency. And that's how Chevron was killed off. That's literally what it was. The government, the agency, it got greedy, very greedy. Diane Fernandez, thank you for the $2 donation. That's awesome. I super appreciate it. That's very, very cool. Now, here's the deal. The presumption is especially strong for statutes where Congress has explicitly left a gap for the agency to fill. I would even say even further rather. Sometimes the Senate and the House and the president who signs off on it will actually leave a provision in there that says you can go ahead and create agreements where you're doing this thing in that direction, right? Like what the SSA has with their future agreements with payroll companies, on this whole digital dollar idea to expedite the likely of knowing if you're earning over SGA and then immediately cut your benefits off. Right? That's the whole idea there. And the Congress allows them to do. They wrote it into the rule. Okay. Now, with that said, in such cases, there is an express delegation of authority to the agency to elucidate a specific provision of the statute by regulation. And any ensuring regulation is binding in the courts unless procedurally defective. Right? So basically, if there's something legally wrong with it, it can't be applied properly. We can't do it. The court has to step in and say, whoa, you made a rule. We're not going to use this because it is, basically procedurally defective. Okay, so if it's procedurally defective, arbitrary or capricious in substance, or manifestly contrary to the statute. So like whatever the intent of Congress was, if they come out with something that's like not in line with that, courts are going to knock it down. They're going to knock down the rule made by the boss of the agency and say, no, bad agency head, you made a shitty little mini law. Okay. Okay, so let's go talk about what just happened, what the new rule is. And then we're going to talk about the SSA and things that could change inside the SSA. The U.S. Supreme Court's 2024 Loper decision. So we had Chevron, it was 40 years old, 1984, 2024, right? And now we have Loper. Chevron over. Loper, the new standard. All right, the Loper decision arises from two cases applying Chevron in the commercial fishing industry. Now remember, commercial fishing is big money. It's big, saucy money, right? Okay, now, two sets of fishing companies challenged a rule issued by the National Marine Fisheries Service. Okay, so our agency here that did a bad thing, they did a whoops, is the National Marine Fisheries Service. Okay, which required vessels, the ships, the boats, operating in the Atlantic herring market, boats fishing for herring, to pay for a government-certified observer during their fishing trips, to pay for a snitch to sit on their boat during the whole thing. And the snitch wasn't cheap, okay? Applying Chevron, the district court in each case rejected the company's challenge to the observer rule and granted summary judgment to the government. Panels of the U.S. Court of Appeals for the D.C. Circuit and First Circuit affirmed it. So just to clarify, the district court was like, boaters, too bad. Sucks for you, buddy. You're going to have to go ahead and let the agency just create whatever rules it likes. Then the circuit court came around and said, you know what? We agree with the district court. Sucks for you. You're going to have to pay for that snitch to sit on that boat and make sure you don't do anything illegal. You want to go out and have fun during herring season? You got to pay our guy and feed our guy to hang out with you during that process. Although the feeding part is, here, there. Okay. The U.S. Supreme Court granted certiorari, Now, when the Supreme Court grants certiorari, you know it's going to get saucy because they're looking at this thing saying, is it time? Do we do we take the old? Do we change? Do we modify it? What are we going to do with this? And that's where the Supreme Court can sometimes come in like this and basically create new law. Okay. So Supreme Court granted certiorari in both cases on the limited question of whether Chevron should be overruled or clarified. Real quick, thank you to Tiffany Ray. Really, really appreciate it. Putting a little star there, putting a little heart there for the $9.99 donation. That's absolutely amazing. Very, very cool. The U.S. Supreme Court held that Chevron was officially overruled. Okay, overruled. Writing for the sixth justice majority, Chief Justice Roberts reasoned that judicial deference to agency rulemaking under Chevron was incompatible with the court's fundamental duty to interpret the law. Put another way, when Congress makes laws, if they're ambiguous, if they don't detail them enough, it is not the job of the heads of the agencies, of the heads of the administrations to figure out what to do in between. It's not. It is the requirement of the courts to figure out what the hell Congress actually wanted done. Now, are the agencies still going to do like their thing? Are they still going to make stuff up and da? Yes, of course. But it's going to go to the judges in the future. And the judges are going to figure out whether or not the agency is doing the right thing. They won't just summary judgment this thing and say, no, we leave it to the agency head. No, we leave it to the commissioner. They're not going to do that in the future. In the future, they're going to review it and figure out if it should be applied. Diana Fernandez with the dollar donation. Very, very cool. That's awesome. Very, very nice. So the court's traditional interpretive rule, okay, the role rather. The courts began its analysis by emphasizing courts' traditional role to say what the law is. According to the court, the framers, right, the old people who wrote very impressive and very important documents, envisioned that the final interpretation of the laws would be the proper and peculiar province of the courts. So the courts are the island of misfit laws that must be reviewed. They must go to them. They must turn them on their side, tickle them a little bit, and see if they're proper. If you don't tickle them, you're not going to get all the little things out of them. It's important. Okay, so with that said, in executing their traditional interpretive duty, courts accorded due respect to the executive branch interpretations of federal statutes, particularly where an executive branch interpretation was issued roughly contemporaneously with enactment of the statute and remained consistent over time. So put it another way, just to like simplify what's happening here, the court said, you know what? We weren't actually doing our job. Our job is to like figure out if these are proper rules. We were just summary judgment in these things. We actually need to look at them at the lower federal court system, because if we don't, then we're just letting the agency continue to pass laws that are beyond the agency's actual legal right to pass laws. But this deference and respect were not absolute and could not supersede the judiciary's duty to interpret the law. So put another way, that's the legal way of putting it, the agencies now cannot de facto create law when the statute passed by Congress was missing stuff or ambiguous. Cool. You guys got it. The court underscores its conclusion by pointing to the New Deal era of expanded administrative rulemaking. Even there, the court explained courts did not defer to agencies on questions of law. They instead applied the test set out in the Supreme Court's 1944 opinion in Skidmore v. Swift and Company. Under the so-called Skidmore Doctrine, a court could defer to agency interpretations of the law depending on 1, the thoroughness evident in its consideration, and 2, the validity of its reasoning, right? Did it make sense? Was it good? 3, its consistency with earlier and later pronouncements, like what was the culture before? Where do we want it to go? And all those factors which give it power to persuade if lacking power to control. All right. A little bit of fanciness with the legal mishmash there, but the bottom line is They looked back in time and said, you know what, the courts, they have a duty, and they weren't doing their duty. And their duty is to interpret these, laws and figure them out as to how things should be done. So this whole thing is about, does the court go ahead and automatically say, no, the commissioner of the SSA is always going to be the rule maker for the in-between rules when they're reasonable? Or do they automatically say, nope, we're going to look at it, we're going to figure it out, and we're going to see if this rule makes sense? That's what this is about. Do the courts shut down and say, no, commissioner, do what you want? Or do they look at it and do they do a full analysis of it? Chevron cannot be reconciled with the APA. This is an important part too. Okay. We're almost to the part where we go through specifically the SSA and how it's going to change benefits and things like that. And please remember to like and subscribe if you enjoy these videos where we go through them and then you understand how the SSA of all places is going to be affected by them. Now, the court also identified an irresolvable conflict between the APA and Chevron. The APA's judicial review provision states that courts shall decide all relevant questions of law, interpret constitutional and statutory provisions, constitutional, big law, framing law, statutory provisions, smaller law, get stuff done law, practical application law, and determine the meaning of applicability of the terms of an agency action. So bottom line is, the APA says, judges, you need to start working more and figuring out if the agency is trying to hurt the people. Thus, consistent with the judiciary's traditional interpretive role, the APA requires courts to exercise independent judgment in determining the meaning of statutory provisions. Now, that sentence is the most important thing. If you learn nothing from this video other than this, I want to read it to you again and then explain really quickly why that's the most important sentence you could have in this entire video. The APA requires the courts, district courts, circuit courts, Supreme Court. The APA requires the courts, the judges, to exercise independent judgment in determining the meaning of statutory provisions, of what Congress created. That's the most important part. Independent judgment. What is independent judgment? Well, it's not what the commissioner or the agency head would have. They're going to pass and put in place whatever they think is going to work best for the agency. They're not going to pass and put something in place that is pro-claimant, pro-beneficiary. No, they're going to go ahead and pass what's easy for them to apply and sucks for the American. That's the problem. That's why the courts have to use independent judgment in determining the meaning of the statutory provisions. The court expressly disagreed with Chevron's presumption that statutory ambiguities are implicit delegations to the agencies, saying, hey, look, for 40 years, we may have been doing this wrong. We shouldn't have given all that power to the agency's heads. The agencies aren't really supposed to create law. We got to pull back from this. An ambiguity, wrote the court, is simply not a delegation of law interpreting power, and courts routinely confront statutory ambiguities in cases having nothing to do with Chevron. More fundamentally, Chevron's presumption is misguided because agencies have no special competence in resolving statutory ambiguities. Courts do. Now, where it gets saucy, the big problem that we're going to be going into a little bit later is that who trains the judges that work inside the SSA? Because, when you read this, you would think, wait a minute, okay, they're saying more fundamentally, Chevron's presumption is misguided because agencies, right, like the SSA, have no special competence in resolving statutory ambiguities. But yet the SSA employs a crap load of judges. So they should have, to some degree, some competence in resolving statutory ambiguities, right? What they're saying here is they don't want the agency and that agency's judges deciding what the rule should be, because the agency's judges have the potential of bias that could potentially create rules and regulations not originally passed by the Senate and House that would be anti-beneficiary, which is what happens. Now, I know what you're wondering. Well, those judges at the SSA have to be neutral and impartial. People applying for disability benefits right now, a good chunk of them would say not, right? They would say, no, they're not, absolutely not. But I then asked you, well, who trains the SSA judges? It used to be a neutral group. It's not anymore. The person who tests to see who should become a judge, literally tests them, gives them a physical test, meets with them, does interviews with them, are SSA personnel. The people who test them, along with the group, are all overseen by SSA personnel. So in other words, the boss of the judges is the agency, which means these SSA judges really could never be totally and completely independent judgment in determining the meaning of statutory provisions. Okay. Now, with that said, Chevron undermines the rule of law. In the concluding sections of the opinion, the court criticized Chevron's inconsistent and unworkable framework. For instance, the court reasoned that the defining feature of the Chevron Doctrine is the identification of statutory ambiguity. But the concept of ambiguity has always evaded meaningful definition. Because, like, how the hell are you can't define ambiguity, because ambiguity is like undefinable. That's the whole point of it. We don't, like, if something isn't defined enough, it's ambiguous. Well, how do you define something that's ambiguous? Well, because there's not enough shit in the writing for us to know what to do. Well, we don't know what to do. So, you know what I mean? That's why we can't define it. Moreover, the court cited its constant tinkering with the eventual turn away from Chevron. The court had not decided the case under Chevron since 2016, as well as Chevron's inconsistent application by the lower courts. In the court's final analysis, Chevron was a judicial invention that required judges to disregard their statutory duties, and the only way to ensure that the law will not merely change erratically, but will develop in a principled and intelligible fashion, is for us to leave Chevron behind. Accordingly, the Supreme Court overruled Chevron. What do you guys think? Do you think agency heads should have the ability to create mini laws where Congress was not very detailed or potentially ambiguous or didn't write anything about that particular situation that might pop up? What do you think? Do you want to leave that up to an impartial judge or the agency head? I would say impartial judge. What's next? Loper marks a monumental shift. Remember that name, Loper, in the respective roles of courts and executive agencies in the interpretation and implementation of federal law. While there are many unanswered questions, we expect the following immediate impacts. Effect on other Chevron cases. Loper expressly refused to call into question the thousands of decisions that have relied upon Chevron to adjudicate APA challenges to federal regulations. These decisions may remain in place for now, but you know that there's going to be a massive, like, everybody that had a problem with one of these, like the EPA or this group or that agency or whatever, you know that everybody's going to be suing these agencies now to get the rules changed. Skidmore deference survives. Under Loper, courts must exercise their independent judgment in reviewing agency regulations. However, the court left Skidmore deference in place. Under that doctrine, courts may still defer to an agency's interpretation of a statute if the interpretation has the power to persuade. In other words, the judges can keep what the agency did if it doesn't suck. Because if it's good and it makes sense, and we're like, yeah, this works. This is practical application. Let's use this. Right? The boat's going to go that way, so we're going to go that way, right? If it makes sense, they can still use what the agency came up with. A new form of deference for express delegation of authority. It is unclear the extent to which Loper will impact agency regulations promulgated pursuant to express delegations of authority by Congress. So in other words, what they're saying is we don't know exactly where this thing is going to go, which means that somebody will sue one of these old Chevron cases that was decided under Chevron, and the courts will start to go ahead and chisel out how this Loper doctrine will actually be applied. You'll see decisions from district courts, circuit courts, but it'll make it up to the Supreme Court. Okay. The court explained that while it is the court's duty to interpret federal statutes, the best reading of a statute may well be that the agency is authorized to exercise a degree of discretion. So what they're saying is sometimes the court may allow the agency to create some law. Okay. In those cases, the role of the reviewing court under the APA is, as always, to independently interpret the statute and effectuate the will of Congress subject to constitutional limits. Loper explained that courts fulfill their judicial function in cases like this by one, here's element one, recognizing constitutional delegations of authority, right? Who's supposed to decide what? Two, fixing the boundaries of the delegated authority. How much power does that person have versus that person, right? Because in this case, it was SSA commissioner versus essentially the Supreme Court, right? So the Chief Justice, right? Okay. Three, ensuring the agency has engaged in reasoned decision making within those boundaries. Okay. So what they're saying is they really need to dig deep, drill down, and figure out what would be the best thing, what would be the best mixture of how the agency could potentially apply this rule, and then also what would be the best thing for the American citizens who have to deal with this rule. The court did not explain, however, if this is a different test than the judiciary's duty to say what the law is, and if it is, when it should be applied. Open doors to challenges. We anticipate a significant uptick in new lawsuits challenging agency regulations across sectors. It remains unclear, however, how courts will apply Loper in the context of particularly statutory schemes and without more specific guidance from the Supreme Court. And what they're saying is the really simple thing here is that bottom line, when it comes down to it, you are going to see a crap load of lawsuits started, especially against the EPA, because the EPA made it really expensive to go ahead and access natural resources. We're talking about oil. We're talking about trees. We're talking about fish. It made it super expensive to access those resources and then sell them and make money. So expect a ton of lawsuits to start coming down with that. Now, with that said, I want to go through some basic things here. There is an issue that I see with the SSA, and I think it's a very crucial issue that I hope you understand with it. There's been a movement by higher federal judges. Federal judges, I'm going to read you the article, just a portion of a very small portion by Aragon Gregg, May 25th, 2023. Federal judges have found fault with almost 60% of disability cases that have been appealed to them in recent years, the highest rate of rejections in years, according to the Washington Post analysis. The findings suggest that the Social Security Administration is making significant errors in its initial assessments of disability claims, which can have devastating consequences for people who are denied benefits and are unable to work. But we know the SSA does this because basically, if you deny people at the very beginning, there's not as many who are likely to appeal. And if they don't appeal, the claim dies. We don't have to pay them benefits. That's the reality here, okay? In many cases, judges have found that the Social Security officials have ignored key medical evidence, failed to properly assess whether claimants can work, and made legal errors. Bottom line, this is what Weiss had to say. The system, this is Stephen Weiss, regional managing attorney for a Bay Area legal aid in Oakland, California. The system is broken. People are being denied benefits that they are entitled to. And what this article is about, just to kind of summarize it real quick, is that a lot of the decisions made by these administrative law judges for Social Security benefits are not setting up a system that makes sense to another judge down the line. So when they make this decision and we're like, okay, this is their decision, they wrote the decision, the judges at the district court and the circuit court are looking at this case and saying, what the hell? How did they even arrive at this decision? What was the systematic approach that they used for this? And that's the problem. That's where the breaking is. The system is not definitive enough with a lot of specifically vocational allowances. Specifically vocational allowances. All right. So you guys know, and this is an important part of the video, that the SSA has a crap load of law. A crap load of law. Okay, Title I grants the states for old age assistance for the aged. Title II, that's your retirement, survivors, disability insurance benefits, your SSDI benefits. Title III grants the states for unemployment compensation administration. Title IV grants the states for aid and service to needy families. Title V, maternal and child health service block grants. Title VI, general provisions. Title 11, general provisions, peer review, and administrative simplifications. Then we got 16. Title 16, everybody knows, is supplemental security income. That's your SSI. Title 18, health insurance for the aged and disabled, right? Your Medicare. Title 19 grants the states for medical assistance programs. That's your Medicaid, right? And then Title 20 block grants to states for social services, Social Security options, things like that. There is a crap load of law out there. I mean, a massive amount of Social Security law. Now, with that said, This new rule, where we switch from Chevron to Loper, where we say, the courts have to figure out if the agency is screwing over the American citizen, what's going to happen is this. We're going to see a lot more lawsuits from attorneys, just like me, who will basically go ahead and create uncertainty on behalf of the agency's authority to create laws that are currently in use, that they created that were not, outlined by the Senate and the House when they actually passed the statute. As a result of that, right, what's going to happen is we're going to see a lot of new decisions coming from higher courts related to Social Security benefits, which is a good thing. It's a very good thing. We're going to see a lot of judges learning the system of Social Security benefits at a much higher level. So instead of having individuals like judges that were like, another disability claim at the federal district court, another disability claim, another one. No. Now they're going to be forced to learn in more detail what the SSA system actually is, which is a good thing. Having more highly educated judges at the higher federal levels, all the way up and including basically those judges who are, justices, that's a good thing. Getting more education on what the SSA is doing to the American citizen at the higher federal levels, huge thumbs up, huge thumbs up. Policy implementation challenges. The SSA's ability to just do what they want, to remove regulations, to put regulations in, those days are over. A lot of the attorneys are going to be able to sue the SSA, specifically the commissioner, to make them answer for why they did something that was anti-claimant. We are now entering that world. The impact on the beneficiaries. Let's just be straight with this. Some of you are thinking, this is amazing. There's no drawback. There's a huge drawback. And the drawback is when we let the courts decide something, when we let the courts figure out what the rule should be, it slows down the process. When the agency wants to do a rule, they set up a review council, they let people comment, and then they make it happen. You've seen it with Commissioner Martin O'Malley. He's got things that were on the bench from Commissioner Kijikazi, and he started popping those things out. When he got in, he's like, cool, looks good, everybody's on board, pop it out. Next one, next delegate, okay, pop it out. Next rule, out. Get it out there. He's getting it done quickly. Those days are limited because the SSA is going to be more scared with releasing ideas because they know in the future the courts are going to have to decide whether or not that rule was fair to the American citizen or just a rule that's going to promote the SSA and make the SSA happy. So the goal of the SSA being more efficient internally, not have to spend as much money on each claimant, not have to legally give as much benefit to the doubt of the doubt to the recipient of benefits. Like the days where they didn't have to do that stuff, they're over. They're over. This is a huge decision that is very good in the direction of essentially Social Security benefits. However, there is one thing I'm worried about. There are couple of ways, 4 main ways to be found disabled, right? You got your compassion allowance listings. Defines exactly what you have to have, then you're found disabled. Then there are your listings, right? Okay, so it's an impairment, little bullet points. You have that, equivalent to that, or worse than that, boom, you're found disabled, right? And those are bad. Remember, the compassion allowance listings are extreme. That means like bedbound. You have a clock on your head as to when you're going to pass away, that kind of stuff. Listings, you're maybe not bedbound, but you're pretty bad. And I always talk about the amputation one because to me, severe is very bad. Amputation, they want both hands or both feet or one of your legs and half your hip. I mean, that's pretty damn bad, to be considered to say that's pretty bad. That's pretty darn severe. That's their standard for severe. Now, then there's the grid outs. If you're older, right? You don't have as much education or you don't have transferable skills that are useful into a new job, well, you can be found disabled, right? That one's got a little bit of a, block approach. Like, you're in the sheets of Excel and you can see this plus this plus this plus this equals not disabled, but this plus this plus this plus this equals disabled. Cool. However, the one I'm worried about, the one that I think is going to be a little bit of a shit show, if you will, are the vocational allowances. Vocational allowances are kind of like your last resort of being found disabled. It's where we know one impairment isn't severe enough. It's where we know de facto that you're not old enough and you don't fit in the grids. It's where we know that we have to look at all of your impairments, totality of all of your impairments, and how they limit your ability to get a job that's a full-time job. Now, you might be sitting there thinking, hey, no problem here. Sounds pretty good to me. Yeah, but here's the problem. Every claim of a vocational allowance is very ambiguous. It's super ambiguous. Like how the judge decides, well, yeah, okay. Right. So some of them are not, all right, let me give you this. Some of them are not ambiguous because they have multiple RFC documents, physician notes that say like what you can do, and they're all consistent. And everything is super cool. And they're like, easy decision. Easy peasy, right? They've got the doctor's notes. They outline your lifting capacity, your ability to, get along with others, learn new functional tasks, show up on time, act appropriately. Man, it's all outlined. You're good to go. That's rare though, because most doctors won't fill those out. And the doctors that will nowadays, money, money, money kind of gig. So they know most people can't get those, which is a really weird, unfortunate bias against the poor when seeking disability benefits. Now, my point with this is, why this is incredibly important, is that when it comes to vocational allowances, the main focus is element 4 and element 5. Can you do your past work? Can you do other types of work? Now, they just changed the rule, right? June 22nd, where they don't care about what you did in the past 15 years. They only care about what you did in the past 5 years. So that's interesting. But here's the thing. I think this is important. The problem is that when you get to the magic part of the decision, and the magic part of the decision is with all of the medical documents that are there, okay, with all the administrative, vocational, legal, financial documents that are in the file, right? ABDEF, they're the C folder they use internally. It's not used by everybody at this point, but ABDEF, right? From that, how do you figure out, right, if somebody is disabled enough to not be able to work a job that's full-time? How do you make that a perfect every time solution where it's not ambiguous? You don't. The person on different categories is going to fit into 0 to 1/3 of the time of a workday they could do that thing, or 1/3 to 2/3 of the time they could do that thing, or 2/3 to the whole time that they're at that job they could do that thing. That's the system, and the system is shit. It's not good. It's super ambiguous. So I do feel that if they go to better define that system in the court system with the federal judges, not with the SSA, we might end up with something that is much more specific, which means that wiggle room where the judges who like the claimant, yeah, okay, I think they're severe, the wiggle room would slowly evaporate. Now, let me explain to you why this is potentially going to happen and be bad. Back in the day, go back 20 years, go back 30 years, go back 40 years, the disability judges were much more liberal. They didn't used to use, way back in the day, vocational experts. They just said, okay, I think this person couldn't work. I even had judges that were so old when I started my firm that they did not use a vocational expert. It was a different world. Thank you, Anna Hempel. That's awesome. Thank you for the $4 donation. That's absolutely amazing. Very, very cool. So the point with this is that, unfortunately, we have gotten more and more and more aggressive at denying claims and judges. And these judges, they just continuously become more and more aggressive at denying and denying and denying claims. In fact, we're at the point with the law firm where we're going to have a discussion tomorrow about whether or not we're going to only accept claimants that are 55 and older, or if they're younger, they have to be VA people, veteran affairs people, prior, soldiers. Because the SSA is becoming so aggressive at denying people that even the 50-year-olds are getting some weird decisions now. So what's happening in this transition is that the SSA is becoming more and more aggressive at closing the doors that allow people to access those benefits, supplemental security income benefits, disability insurance benefits. So what you're seeing is the numbers for disability applicants and SSI people, basically for disability benefits of those portions, going down. And you see over 100,000 people on SSI benefits coming off the program. They have not, by the way, produced any documentation as to how many non-citizens have gotten onto SSI benefits since December of 2021. So you know that they're hiding something, and you know that it's not good. You know that the amount of non-citizens going on to SSI benefits has skyrocketed, which, just so you guys all know, comes from the general tax funds, a lot of the same funds that they were using to sometimes pay Ukraine. The point is, and I always love that, it's like, we should make sure Ukraine has a proper border and people can't get into it. And then on the other side, you got Biden. He's like, you know what? Let's get some welders. We're going to weld those gates open. It is time to make this good for people. And his good for people is unfortunately allowing anybody to really cross into the border. It's scary. It's very unique. I don't think we'll see that in the future. The point is, with this whole thing, and I think this is incredibly important, in the future, it is the direction of America that wants to reduce the amount of people on disability benefits. Think I'm wrong? How many people do you see screaming in the comments about, I know this fraudster, I know this person, I don't think they're that severe, I don't think they're that bad, I can't see their, impairments, I can't see their conditions, so surely they must not have them. It is the direction of the American people, which is the direction of the executives we put in place, which ultimately can affect the judiciary with deciding how open the doors are for an agency to release those benefits, to grant them, right? Melissa Y, thank you for the $20 donation. That's absolutely amazing. Really super duper appreciate it. That's awesome. So the point is with this, I am worried about future courts giving very specific elements to vocational allowances, because at this point we have a wiggle waggle system. The judge could wiggle waggle and say, yeah, they could do a job. The judge could wiggle waggle and say, no, I don't think they could do a job. And that's the vocational expert portion of the hearing. That's at the very end, right? You have the intro, the examination, cross-examination of the claimant. Then you have the vocational expert portion with the hypothetical questions. And then you have the outro. So the vocational expert portion, the judge asks the vocational expert, hey, could a hypothetical version of this person do this, this, and this? Vocational expert says, no, they say, hey, are there any jobs that exist within this hypothetical? And the vocational expert goes, well, there's this job. Okay, what if we make the hypothetical person more disabled? What if they couldn't do this, or this? And the vocational expert goes, well, this job would still exist, but these two jobs wouldn't exist. And then the judge goes, what if they're 15% off task? What if they're 20 days missed for the year? Blah, 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 blah. Oh, work reclusive. There's no jobs. There's no jobs. There's a lot of wiggle room in there. A lot of wiggle room how the judges can decide if somebody should be found disabled. If you make vocational allowances very rigid, you're not going to like it, because there's no way to magically every time get it right and say, okay, we got this impairment, this impairment, this impairment, this impairment, this impairment, this impairment. Take them all, throw them in the pot. We're making a soup. The soup is the disability soup. Is this soup moderate in limitation or severe enough in limitation? There's no way to magically make that work. But if you start adding really specific niche, really specific elements that have to be met, none of you are going to like that, because that wiggle room is going to disappear. And then all of a sudden, it's going to make it significantly harder for people to be found disabled. All right. Also, just a little side note, I think things are getting spicy for these judges. Florida Bar just released basically their newspaper. Federal judges grapple with escalating threats. Let me just read to you a real quick thing, because what's happening is last year, 457 federal judges were targeted with credible threats, 150% increase from 2019, according to the latest U.S. Marshal Service figures. Bottom line is, political figures, as you may have seen, are in a lot more danger than they ever have been. And it's very unfortunate what happened to Donald Trump. I feel terrible that the situation happened to him, and I hope that he heals up well. Getting hit with a bullet is never an easy situation. I was personally, unfortunately, shot at in Colorado one time, and it was a horrible, horrible feeling because the bullets were literally bouncing off the bank where I was in this little ditch thing on the side of the road, because in Colorado the roads are built and then they have like a big ditch right next to all the pieces of land, and just shooting that rifle right, and it was just crossing right in front of me and they were bouncing. And when it happens, it's a horrible experience because there's these little death things, and you can't actually see the bullet. It's just little puffs of dirt that pops up from where they're shooting at you. And what happened was one of the neighbors over there, who was a chaplain for the local jail, saw me with a camera because I was just shooting some stock footage, and he was like, "Oh, I'm going to get this guy. This guy's probably with the tax department, shooting basically footage of me, basically on my land. My land's going to go up and I'm going to have to pay more taxes." So, bottom line was horrible experience for me. And, but it happens. And with that said, U.S. District Judge Thomas Barber was impressed with some of the perks that came with his new job, including a free home security system, when he left the state bench to serve in Florida's Middle District 5 years ago. We also get a service called Delete Me that gets our name taken off the internet, and it's paid for, he said. We have an office in Washington whose only job all day long is judicial security, which of course they need it because people don't always love judges because the decisions they make are not always things that they love, especially in family court. Last year, 457 federal judges were targeted with credible threats, 150% increase from 2019. Barber and Chief U.S. District Judge Timothy Corrigan say the increase is being felt in the sprawling Middle District, which serves more than 12 million Florida residents, with courthouses in Jacksonville, Ocala, Orlando, Tampa, and Fort Myers. Let me just tell you this. Florida, specifically Central Florida, got a lot of Californians. It got a lot of New Yorkers. It got a lot of homeless individuals. It got a lot of people who basically are acting up. And as a result of that, we are seeing more aggression towards doctors, more aggression towards attorneys, more aggression towards judges. Difference is the judges get people who basically will go ahead and do security for them. There's a bunch of provisions and things like that. They're figuring out ways to give them more security because judges are unfortunately being targeted in horrific new ways. But remember, you don't ever want this happening because it can potentially bias the judges against the American people, which you are always on the side of, whether you like it or not. You're stuck on that side. You're stuck on the side of the American people. You want them to lean in your favor based off of your needs. So with that said, I hope you enjoyed this video. Please remember to like and subscribe. Head on over to Google and type in Disability Resolution Law Firm or Disability Resolution Florida. Throw some stars up there. I always appreciate those reviews. I will catch you a little bit later, but please remember I go live on Tuesdays and Thursdays to go ahead and answer calls, usually at night around 10 or 11 p.m. on YouTube, where you get to call in and I answer the questions for free. With that said, if you need me for a full hour, and this is a super popular thing, I do private sessions. So you can hire me for 1 hour. The little mini contract is below. A lot of people use them for preparing to transition from work to the benefit system, LTD benefits, SSDI benefits, getting ready for a hearing because they can't get a hold of their other attorney, which is always ironic, or all kinds of things. OIG is chasing them down, and we have coming up some actual video footage of law enforcement officials interacting with the disabled that we're going to be posting up on this channel. So a lot of those people who are like, they would never do that to a disabled person. We have the videos. We have the body cams. We have the cell phone, and we're going to be posting those things on this channel so that you can actually see it for your own eyes. I will catch you all a little bit later. You have a wonderful night, and please take care of yourself. Attorney Walter Hnot. I'm going to be doing one more video after this, but give me about 15 to 20 minutes, and we'll catch up then. Thank you so much. All right. Bye-bye, everybody. Bye-bye.